his beds, if he has more than one, and he decided to think that they can again be asked whether what they provided before, even before it works, they can rethink what they did. In my opinion, Right Honorable Chair, we are saying, in the opinion of the Democratic Party, we are opposed extremely to any intended amendment of this, particularly provision Article 102B, for those reasons. Right Honorable Chair, as I intend to conclude, Right Honorable Chair, another authority which I will also give is the one of Minerva Mills Limited versus Union of India, 1980. The citations are going to be given to the committee for further scrutiny. Right Honorable Chair, let this committee also take very, very serious care. When you look at our Constitution, particularly Article 2, we are living in grave danger. Particularly you, Right Honorable Chair, and you, not, of course, second person singular. I mean you that are engaged in the business of trying to amend this particular provision of the Constitution. Article 3, paragraph 2. Right Honorable Chair, if I could read it, then I dissect it. It says any person who, singly or in concert with others, by any violent or other unlawful means, suspends, overthrows, abrogates, or amends this Constitution or any part of it, or attempts to do any such act, commits the offense of treason and shall be punished according to law. Right Honorable Chair, when you discern properly this provision, in its own right, it creates the offense of treason. Now, this Constitution, particularly this provision, is self-executing. For all of you lawyers will agree with me that an offense of treason is created under here. But there must be ingredients if an offense of this nature is to be actually looked at. And I'm getting there. I know there are questions that need to be raised, but I am also getting there. Now, these are the ingredients that one needs to look at. All lawyers that are looking at this provision. The first ingredient, there must be a person. 2, that person must either be single or in concert with others. 3, there must be evidence of violent means. 4, there must be an amendment or attempt to amend either the whole Constitution or any part of it. Now, of course, Parliament is given immunities, and I am aware as an advocate, under Article 97, which eventually, of course, culminate into other enactments that provide for immunities. But lawyers need to know that this is a specialized offense, probably different from, and I would like...
I'm really at pains to...
If I am done with this interpretation. Because 1, the ingredient of violence once cited extinguishes the possibility of you having amended it according to the law prescribed under the amendment. This Constitution is aware that Article 3 was aware it would find an article on amendment of the Constitution. So yeah, I know that that was within the precincts of a motion being introduced for purposes of intending to amend this article. Now, the offense here prescribed in this Constitution, cause of action arises during and or after. Now, therefore, even during a cause of action of this nature can arise. Now, Right Honorable Chair, there is a possibility that liability can be inferred against specific members who can be proved to have taken part of the conspiracy to have this amended, while violence has been vended as one of the best tools applicable in terms of amending this article. So, Right Honorable Chair, it is therefore prudent that we provide it before this honorable committee. You take stock of the availability of criminal wrongs that are likely to have been, that causes of action may arise even during. If this committee does not extinguish your work, it may arise even before a report of the nature of the results of this kind of inquiry will have been brought out. Right Honorable Chair.
Clarification of the committee and my colleagues here. I am excited to be here. I feel at home when I cast my eyes on many of you with whom I used to share political company during the good days. We are not going to war. We are going into an intelligible discussion to discuss the fate of the grand norm, which is a national concern for all of us. So let us take it easy while we are serious. In this presentation of the Conservative Party, I would like first of all to bring you greetings from the Conservative Party. I will segment my presentation into several numbers so that you get and capture the issues I intend to tackle constitutionally. I would like to state something regarding what went wrong on the 27th of September 2017, in our view, in the party, that tragedy has a political constitutional significance. I will also talk about the history of constitutional law in Uganda and the CP's stand on the proposed amendment, and eventually give a surgery on the amendment, let alone recommendation, without losing sight of the issue of the rules of procedure as handled by the Speaker of Parliament on that day. Madam Chair, because of the significance of this presentation, for the first time I'm putting on glasses to make sure that I unveil every significant aspect of discussion regarding the constitutionality of this issue.
Which page are you?
The Conservative Party is concerned about the tragic circumstances that led to the invasion of the People's Parliament by the Presidential Security Guards on the 27th of September 2017. The Right Honorable Speaker's recent letter to the President in search of an explanation which led to that fateful event, in my view, is evidence to prove that the state of Uganda had a hand in the invasion. What was at play in Uganda's parliament on that memorable day, Madam Chair, is a replica of the 1966 constitutional crisis when Milton Obote deployed the Uganda Army at the National Assembly to superintend over the passing of the Pigeonhole Constitution in replacement of the 1962 Federal Constitution. More light, Madam Chair, in that direction can be sought from my latest book on the federal doctrine and the birth of the Ugandan nation, which is at public play. Madam Chair, the attempt to remove the presidential age limit under Article 102B of the Constitution through brutality and the beating of legislators opposed to that initiative, led by presidential military guards, was an act of tyranny which negates the tenets of the people's liberation struggle based in Luwero to free Uganda from the oppression and omnipotent dictatorship as relatedly stated in the preamble of the 1995 Constitution. Madam Chair, in light of that, therefore, the Conservative Party hereby advises the committee, this esteemed committee of Legal and Constitutional Affairs and Parliamentary Affairs, to quash the emergency bill on the strength of the following reasons. And I have itemized them scientifically so that it is easier for you to grasp the issues as...
Please go ahead. Yeah, this is very easy for us to grasp.
The first one is that the 1995 Constitution is a baby of the NRM regime, and nobody can doubt that. It should be given time to be tested, because the testing is just beginning. The framers of the basic law tailored Article 102B on the basis of our faithful history. That constitution should be given time to prove its worthiness. It has not yet proved its worthiness. You are hijacking it, you are suffocating it, you are killing it. Why are you in a hurry? You are not going to the moon. Take your time. Number two, Madam Chair, the ambition for any person to rule Uganda for more than 35 years is a cause of disaster, and whoever is behind it aims at creating a life presidency in Uganda and a one-party regime contrary to the endeavors of Article 75 of the Constitution. As you know, Article 75 of the Constitution forbids any attempt to make Uganda a one-party state. I can see that direction being taken. Chair, before attempting to amend Article 102B of the Constitution, the framers of the Magezi Bill should have looked beyond Articles 259 and 262 of the Basic Law. Those of you who have not read Article 259 of the Constitution, I beg you to do so. Those two provisions should not be read in isolation of Article 1, Article 20 of the Constitution. One is about power belonging to the people. The other one is about fundamental human rights being derived from God, not from the state of Uganda or President Museveni. In Article 259, Madam Chair, sub-Article 1 of the Constitution, for example, I've taken trouble to study this provision. Elements of addition, variation, and repeal cannot be meaningfully assessed through a private member's bill when measured from the yardstick of what the Supreme Court recommended in the electoral petition of Amama Mbabas versus Lukyamuzi 7 and the Electoral Commission 2016. The Supreme Court's recommendations in that petition were directed to the government of Uganda, whose response ought to have appeared in the form of a Constitutional Review Commission other than a private member's bill. Madam Chair, the Supreme Court recommendations were not directed to Honorable Magezi as a person. The equivalence of the Magezi motion should therefore be decided by the entire Parliament through a vote or an appropriate committee. Government cannot personally handle that provision of moving an amendment, because the amendment, as recommended by the Supreme Court, was directed towards the people of Uganda or a representative framework of the people of Uganda. Number 4, and this is most important, good legislative practice, Madam Chair, is highly dependent on the observance of the rules of procedure. And here I'm speaking as someone who left a mark in parliamentary debate in this parliament. I'm not talking out of context. I'm relevantly positioning myself.
Even if you don't say it, the Hansards will speak for you.
So the Right Honorable Rebecca Kadaga, the Right Honorable Kadaga did not preside over Parliament on the basis of the rules of procedure in the parliamentary session of 27 September 2017. The Speaker acted in open abandonment of the rules of procedure and could not control the House. For example, in open defiance of Rule 69 of the current rules of procedure, the Speaker openly ignored the good point of procedure raised by the Shadow Minister of Constitutional Affairs, Honorable Rubega Segona, over which the two motions between Honorable Magezi and Honorable Nsamba would respectively be moved first. Even after indicating that the Leader of the Opposition wanted to react on the movement of the Magezi motion, the Speaker of Parliament openly ignored the Leader of the Opposition when she stood up to say something, and in so doing, she acted in open defiance of the rules of procedure of Parliament in the Commonwealth of Nations to which Uganda is affiliated. What a shame. A Leader of the Opposition is a significant factor in the constitution of what is referred to as a multi-party dispensation. Number 5, as a former chair, I wish to remind this committee that in accordance with the current rules of procedure, notably Rule 61, no motion, whether it is presented for the first reading or not, can be passed without undergoing scrutiny. Any motion, including a motion paying tribute to a dead member of parliament, can be quashed circumstantially. No motion can be passed by assumption. The sectorial motion on judges is a good case in point. It was last year technically quashed on the first on that day. Interested to comment the Conservative Party saying. In conclusion, the Conservative Party proposes that the Majesty motion now before your esteemed committee be withdrawn on the following grounds. And this is a surgical operation. 1A, the Majesty motion was sent to this committee in open breach of the rules of procedure of Parliament, as we have explained above. And I have at length attempted to explain that dilemma. B, the Majesty bill has been facilitated with the funds amounting to 29 million shillings extended to each member of Parliament, drawn from the consolidated fund without formal parliamentary approval, which is contrary to Article 93A, Roman 3 of the Constitution. C, the bill is a nullity and has no qualification, therefore, for being debated in the House. Why do you debate a nullity? It is time wasting. 2, the Majesty motion is a ploy to make President Museveni a life president. In 2021, and this is very serious, honorable members, the current president will have spent 35 years in power. There is no sound explanation for retaining such a person in power beyond 2021. The preamble of the 1995 Constitution grossly discourages the monopoly of presidential powers beyond the age of 75 years. There is therefore no need to amend the presidential age limit constitutional provision because Uganda still needs that provision. 3, the attempt to amend Article 102B of the Constitution on the basis of bribery is absurd, and Ugandans are not prepared to allow that to happen. The legislators have partially been bribed in accordance with the database we have exhibited above. In protection of the Constitution, therefore, Madam Chair, no one should be alarmed by the Majesty bill being scrapped. Article 3, finally, of the Basic Law permits the aggrieved persons where the Constitution is arbitrarily tampered with to act to the extent of employing force to rescue the population from misrule. If you can do that appropriately, you commit no wrong, provided you have the database of wrongdoing. So, finally, Madam Chair, if we were the Speaker, if the Conservative Party was the Speaker of Parliament in Uganda today here, our obiter dictum before the members of Parliament would state as follows, and I read verbatim. It doesn't have to bribe the members of Parliament to appropriately amend any provision of the Constitution, because under Article 255 of the Constitution, when read in conformity with Article 1, Article 20, Article 23 of the Constitution, the people under the direction of the Referendum Act 2005 can subject the presidential age limit amendment to a referendum. And once that is done, the outcome of the referendum takes precedent over the decision of Parliament on the same issue. If Ugandans choose to end with a referendum on the matter of Article 102B of the Constitution, it does not matter whether Parliament takes a decision or not, because whatever decision is taken by Parliament, including bribery, can be overwhelmed by the national vote on the basis of a referendum. So why buy members of parliament if you already know that there is a checkpoint and a referendum?